Good afternoon. Our first case will be Atlantic Casualty Insurance versus Gustafson. Minutes each side. Please proceed.
Good afternoon. If it please the Court, David Anderson. I am the attorney for appellant Atlantic Casualty Insurance Company. I think the issue for this Court's consideration is relatively simple, and it's whether the Court of Appeals analysis and interpretation of the phrase any property owner in the definition of contractor in the policy is clearly erroneous. The premise of the Court of Appeals analysis of this issue was based on the erroneous conclusion that the phrase any property owner is ambiguous because I conceded that the interpretation advanced by the appellee would constitute an absurd result. The fact that there would be an interpretation of that phrase that would result in an unreasonable or absurd result certainly does not render that phrase ambiguous. My argument to the Court of Appeals and to this Court is that the interpretation of the phrase any property owner must be considered in the context of the entire definition, all of the words that are used, in order to harmonize those words in order to avoid an absurd or unreasonable interpretation. The application or invocation of those principles which govern the interpretation of the terms and conditions in every policy does not mean that the word or phrase that is being interpreted is ambiguous. And the fact that the Court of Appeals was asked to interpret that phrase does not mean that it's ambiguous. Both the trial court, putting aside the issue of whether it is or is not ambiguous, which I contend it is not, both the trial court and the Court of Appeals, however, did review all of the words that were used in the definition of contractor in reaching its conclusion of what the meaning of that phrase
Counsel,
is.
do you see how the insured would be kind of surprised to find out that this coverage is not applicable? I mean, do you see that that could cause some kind of a surprise?
I think there are many circumstances in which insureds, after reading the policy or having it explained to them, are surprised that they don't get.
Even the agent was surprised.
Well, the agent, we have no information about the extent to which the agent read the policy. The agent was an independent agent. The mere fact that the insured said that his agent led him to believe or told him that he had coverage, in a vacuum, that really has no meaning or relevance because we don't know whether the agent read the policy. You have to consider and review the phrase any property owner in the context of all the persons and entities that are listed in the definition of contractor in order to determine its meaning. And that's in fact what the Court of Appeals ended up doing, although I disagree with how they got there. Both the trial court and the Court of Appeals looked at the entire definition.
Yeah, you raised the point that it was an independent agent. Is there a significant difference between an independent agent and an insurance broker? And to the extent there is, to whom do they owe duty?
Well, an independent agent is the agent of the insured and is not the agent of the insurance company. A broker which places coverage through an independent agent is a representative of the insurance company. We're not dealing with a situation where this insured went directly to a broker for the policy.
And you believe the case law is very clear that an independent agent is the agent of the insured?
I believe it's very clear that an independent agent, if it's a captive agent, and my client doesn't have captive agents, but for example, State Farm, they have captive agents.
They're not independent.
They're not independent. and they are an agent only of State Farm Insurance Company. An independent agent is not an agent of any insurance company. They represent multiple insurance companies. They are the agent of the insured. But the statement by this independent agent, again in a vacuum, has no meaning without knowing to the extent to which the agent was familiar with the policy, whether or not he or she had read it and understood it. The Court of Appeals and the trial court...
Does this sound like the kind of policy a person would really, under your definition and what we're discussing here today, does this sound like the kind of policy that like people would want to purchase based on your argument? What would the advantage to a policy like this be?
The intent of this policy as it relates to a property owner was to exclude coverage for any property owner that had a commercial or financial interest in the work that was being done. And that, I believe, is clear from reading all of the persons and entities that are listed, which are contractors, subcontractors, employees of both, and any property owners. Any property owner, as both the trial court and the Court of Appeals concluded, although differently, the trial court concluded that property owners are those who have an interest in the project that is being performed. The Court of Appeals, I believe, narrowly construed it to be limited only to those that derive some sort of compensation from the work that's being done. I believe that's an overly restrictive interpretation of who has a commercial or financial interest. And I think that's evident by the fact that any buyer of goods or services has a financial or commercial interest in either the goods that are being purchased or the services that are being purchased. In this case,
leave aside financial, but what's the commercial interest of a private individual in buying a product or service? What's the commercial?
Commercial interest is that he or she pays money for work to be performed. And on this case, Mr.
Aren't they the consumer? I mean, I think of the commercial enterprise as the business enterprise. You know, I'm looking at definitions. Somebody engaged in profit or in commerce to yield a profit suitable for wide or popular market. You know, a product that you can sell broadly, suitable for catering to business rather than private use. All of these things speak of someone who's in the marketplace, in the business world, providing goods or products to private individuals or consumers of the product. But it's hard to understand what the commercial interest of the consumer is. Private individual.
The financial interest, of course, is the fact that he was paying money to the insured to have work performed on his property. He actually provides consideration to the insured.
You've amended my question because I said leave aside financial and just talk about commercial. So are you yielding on commercial?
I don't think that they're mutually exclusive in the context of the meaning of this definition. They are all entities that, as the trial court concluded, that are commonly found on a construction site. And whether it's a residential property owner or General Motors in terms of a construction project, they're both property owners. And the intent was not to provide coverage for any property owner that has an interest, whether you call it commercial or financial, in the work that's being performed on the project. In this case, it happens to be a residential property owner. If this had been General Motors, I don't think that the analysis would be any different. They're also a property owner that has an interest in the work that's being performed on their property for which they've paid consideration to another entity to provide goods or services or equipment. All are entities or persons that are commonly found on a construction site, as the trial court concluded, and are excluded from coverage under the policy. And that's the reason why I believe in the definition the word any property owner was used. It's very broad because in the context of a construction project, we're not only talking about the owner of the property on which the work is being performed, but we're also talking about owners of materials and equipment that may be supplied for the performance of the work on the project.
You raise an interesting point, which is your client obviously could have written the policy better than they've written it, right?
It's not perfect, and I agree that it could have been written better, but that doesn't, in my opinion, render it ambiguous. If you're asking me, what would I have done?
That's why they wrote any property owner. So they could.
What would I have done? I would have taken the word property owner and given it a special meaning by putting it in quotations and then defining it as the owner of any property on which the work is being performed, or the owner of any materials or equipment that is being supplied for the performance of the work. That's what I would have done, but I believe that that meaning is clear and reasonable when you look at the term any property owner in the context of the entire definition and the other entities and persons that are listed.
And your client is satisfied that it's clear even after the Seventh Circuit and the Connecticut Supreme Court thought it ruled that it meant something else? Obviously, we don't have to agree with those courts, but any idea why your client didn't say, maybe we have to amend this because these courts keep saying our language means something we don't think it means?
Those two cases I submit are both factually and legally distinguishable. In the Connecticut case, the Toronto, I believe, the courts applied Connecticut law, which gives deference to the language in the heading or title.
I understand what the cases say, and I understand why they're distinguishable. My question was, you want us to say that the language is clear and it means what you think it means, and I'm just asking if those other decisions don't give you any pause about exactly how clear it is. I mean, if you were the general counsel for your client for the whole, would you have rewritten this in 2013 maybe?
Yes, but the problem is with regard to the Connecticut case, it's looking at the title or the heading of the exclusion in a vacuum and ignores the definition of the word contractor, which is contained in the heading. Every exclusion in an insurance policy has a heading or a title, followed by the terms of the exclusion. And some of those terms have words or phrases that are given special definitions which govern their meaning. You cannot interpret the exclusion by looking solely at the title or the heading without considering all the terms and conditions, including any definitions that govern the meaning of the terms and phrases that are used in that.
Counsel, am I correct that even the trial court did not interpret the exclusion in as broad a manner as you did in terms of the language that followed your or? In other words, you talked about the owner of the property in which the project was being carried out, but you also had an or that referred to the owners of a great deal of personal property as well, did you not?
Well, I think that what the trial court's ruling certainly contemplates that, because the trial court said these are persons or entities that are commonly found on a construction site. That would certainly include the property owner, any contractors or subcontractors, and suppliers of materials and equipment. All of those fall within the classification that the trial court concluded what any property owner means. So,
do you think it's a reasonable interpretation to give both a personal and a real property interpretation to this phrase, any property owner?
I do not agree that it covers the owner of any property that has nothing to do with the work that's being performed on the property. That's the argument that's advanced by Appellee, that any property owner means everyone, which of course would effectively exclude coverage for any claimant, because everyone, with the exception of a newborn baby, owns some property, including the clothes on their back. And that, I believe, is an absurd result, an unreasonable one. And that's been the argument that's been advanced by the appellees since day one, is that it's ambiguous because it effectively excludes any claimant from coverage and therefore renders the coverage illusory. I think that my position is, and I've advanced it since the beginning of this case, is that's an absurd result. And any interpretation of a word or phrase that results in an interpretation that's absurd is to be avoided. And my position is that argument should be avoided and should be rejected. And just because that's an argument that's advanced by the appellee as to what this means doesn't render the phrase ambiguous. We frequently, courts are faced with having to interpret words and phrases that are not given special meanings in order to determine what the intent of the particular provision is.
So if there's a friend to the property, the real property owner in which the project is being carried out, if there's a friend who in the course of going with the property owner to his property loans one of the workers a screwdriver or a hammer, that person automatically becomes subsumed within this exception too. Is that right?
I don't believe so. That's not someone that has an interest, a financial or commercial interest in the work that's being done. They would simply, they'd be a third party. It would be like, oh, you've run, for the owner of the brush hog machine, runs out of gas. A friend of the property owner is there watching the work being done. In his pickup truck, he's got a can of gas and says, I'll loan you the gas. The gas is his property. He doesn't have a financial or commercial interest in the work that's being done. That interpretation would be consistent with the one that's being advanced by the appellee, that any property owner is excluded from coverage. That would be an overly broad interpretation that I believe would produce an absurd result.
So it has to be a commercial interest by your understanding.
Commercial or financial interest. And I believe that a property owner who pays an entity, a company, to perform work or services on his or her property has either a commercial or financial interest in that work that's being performed.
Is that property owner's spouse, if say she's not listed on the deed or the mortgage, but if she gets divorced can get half of the value of it, is she a property owner?
If she doesn't have legal title to the property or own it, no. And I don't think you would consider it in the context of what are her rights in the event of a divorce.
So just the person on the deed is
just
covered.
the owner of the property.
The other people who live in the house could get coverage if
Absolutely.
they got hit in the face. Yeah.
As would be a neighbor or a friend who happens to be visiting the property owner at the time the work is being performed and some act occurs that results in an injury. They would absolutely be entitled to coverage.
What if there's a utility project of some sort in which the property owner has no interest any greater than any other member of the public? That he doesn't hire them to perform, I believe that they would be covered as well. Because that utility work would be, I assume, performed on an easement that the utility company has of the property, and so I don't believe that this would operate to exclude coverage for an employee of a utility that's not hired by the property owner or by a contractor that was hired by the property owner to do the work. Any other questions? No, thank you very much.
Thank you.
Mr. Nordine?
Good afternoon, Your Honors. Attorney William Nordine for Gary Gustafson, the insured contractor in this case. As you know, we're dealing with an exclusion to an insurance policy. We're not dealing with the policy or another contract. We're dealing with the exclusion. And the exclusion to insurance policies are strictly construed in favor of coverage. So we got to start there before we go anywhere else. And there's a couple of ways to approach this, and I think we saw them in those two other cases. In Connecticut, the court looked at this policy of insurance and they found that the homeowner or the customer was not included. It was not meant to be included. So from the four corners of that contract, they didn't find it was ambiguous, but from the four corners of the contract, they said they did not envision that the words meant that the homeowner or the customer was supposed to be a contractor, which I agree because that would be absurd. When we talk about absurd results, making the customer of a contractor, the homeowner, making them fit into an exclusion for contractors is an absurd result. So I think Connecticut went that path. Then we go to the Seventh Circuit and Judge Posner, and he looked at it and he gave a possible credibility to this extreme notion that it's any property owner or it's, in that case it was anyone providing services, And with that, he said it's ambiguous because it's not clear. I mean, he looked at this exact same exclusion, and it's exclusion for contractors, and he determined that there was a better reading into it than what was being pushed for by Atlantic Casualty. So then that means that it is ambiguous.
It's not ambiguous to say there's a better reading. There's
Yes.
always better and worse readings. That doesn't transform something that wouldn't otherwise be ambiguous into something that's ambiguous, does it?
I agree, because that's what Connecticut did. They said that, hey, you know, the homeowner isn't involved in this thing. We don't have to find it ambiguous. But if you find multiple readings, so if you find multiple interpretations, so there's one interpretation that's extreme, there's an interpretation that we would say, which is someone with commercial interests only, and the interpretation which is kind of in between that Atlantic Casualty says, then what the law says, you have an ambiguity, and you find strictly in favor of coverage. That's where I think we end up, and we end up with those two choices. I think the Court of Appeals went the route of the ambiguity, and I think they were proper with that. I think there was an ambiguity, and we need to strictly construe it in favor of insurance
Are
coverage.
ambiguities in a contract factual questions for a jury?
I don't think no, I think that we have case law that says that they're strictly construed in favor of coverage.
I'm reading Clapp, which says where a written contract is ambiguous, a factual question is presented requiring a factual determination as to the intent of the parties in entering the contract. I mean, how does a court determine a factual question?
Well, I think what we saw the court in the Seventh Circuit do that, where they find an ambiguity, and then as a matter of law, you apply this strict scrutiny to the ambiguity and to the choices you have from the different possibilities, and you go to the one that offers you the coverage. I don't think we get to a fact question in this case, because it's really about what's written in the exclusion and whether or not it makes sense, for one thing, whether you end up with this absurd result, whether it makes sense to put a homeowner in an exclusion for a contractor, and whether it makes sense to have strict scrutiny in favor of insurance coverage as a matter of law.
Can I not be of the view that you've gone through the right process in trying to give meaning to this term? There are a number of reasonable interpretations that could be given to the phrase, and I think you've gone through an entirely appropriate process, but I don't think you're giving respect to the way that this court has used the word ambiguous. We've said that ambiguous means you get to decide something determine that something is ambiguous only if it's equally susceptible to more than a single meaning. You've concluded there is a better meaning and a worse meaning.
Yes.
So isn't that the meaning that you're urging upon this court?
Yes, I think that.
Okay, so it's not ambiguous.
I guess I'm back to what Connecticut did. They didn't find it ambiguous because they found a better meaning.
Connecticut, I know a little more about Michigan, and Michigan says ambiguity means what I've just said it means.
Right, but I mean, we don't have to get to the ambiguity. I agree with that, if that's what you're saying, Your Honor. We don't have to get there because we have strict scrutiny in finding coverage. And yes, I think from the four corners of this document, it does not make sense, and you cannot tell. We're back to the surprise that Justice Bernstein said. You cannot tell from this document that a homeowner or a customer would be included in an exclusion as a contractor. They're not a contractor. So I think that, yes, it can be determined without finding an ambiguity. It can. And I think that's why I attached that flow diagram that I tried to work through, because I was trying to make sense of it all. I was trying to make sense of all this law and try to figure out, okay, we start with this. Is it an ambiguity or is it not? And where do we end up? But whether you find that there is no ambiguity and the right reading of this contract does not include the homeowner as a contractor, I agree with that. But if you give any kind of credibility to the claim by Atlantic Casualty that the homeowner should be a contractor under this exclusion, then you end up with the ambiguity. And again, then you give it strict scrutiny and we end up with insurance coverage. So I think no matter which path you take, we end up with the same result, which is that there is no way that this homeowner, this customer, should be included in an exclusion for contractors. It just doesn't make any sense whatsoever.
Saying it doesn't make any sense just really isn't a very persuasive argument to me. I understand the argument why any property owner might not refer to the injured person in this case, but I think it takes a more nuanced argument than simply it doesn't make any sense.
Okay. Okay, I think that it doesn't make any sense that, we have certain terms that we give to people. And a contractor is a certain party to improvements to property. There's a contractor, and we know what a contractor is. We could find that in the Construction Lien Act and other places in the law. We know what a contractor is, and we know what a customer is. And to try to make the customer fit into the contractor exclusion is bastardizing the whole thing. It doesn't fit there. It's absurd. It's making this absurd way of trying to try to exclude coverage. It's not there. Not to mention that it's not fair because we can't reasonably see that. So the insured can't reasonably see that this homeowner should be excluded. So when he got this insurance policy, he never had the opportunity to understand that and decide if he wanted to buy it. Judge Posner said that, made that comment that he said that if this was taken to its extreme, who would buy such a policy? Well, that's true, but you have to know it's out there first before you can make that decision. And we can't have hidden meanings within insurance policies and then still have a meeting of the minds. And isn't that what we have at the end of the day with contracts, a meeting of the minds? And we can't have the meeting of the minds when we have hidden meanings hanging out there that later on insurance companies bring up and try to deny coverage. I mean, this is the kind of case that really falls under this general commercial liability insurance. And the idea that this homeowner, this residential homeowner, has a commercial interest in this project is not right. It's not a commercial interest. A commercial interest. The term commercial interest is something that the Court of Appeals, I think, tried to put to what these other courts were saying. I mean, the court in Connecticut said they envisioned people making improvements to their property, being paid for that. Judge Posner said the same thing. He had the fellow there that had provided services. He had caulking of windows. That was services, but he wasn't under contract yet. So he envisioned them under contract, being paid. So that's what we're saying here. That's what we're seeing.
I mean, I agree. If any property owner were literally to mean any property owner, that would be a very dubious and concerning understanding. On the other hand, among the universe of property owners in the world, it seems to me the most likely one to be covered would be the one on whose property the work is taking place.
But if that was true, Your Honor, then they should have made that clear and call it the real property owner. Because what you have here is you have an exclusion called exclusion for contractor, and then you have, like Judge Posner said, the exemplified word contractor. And the contractor follows that as a list of what contractors are. And they threw any property owner in there. That would lead you to believe, I would think, that it's any property owner with a commercial interest. It's any property owner that is a contractor. I mean, commercial interest is just another word for contractor. So what you're saying there is that there's an exclusion for contractors. Here's our list of contractors, and any property owner falls in there. They didn't say real property owner. As you know, these are very sophisticated people drawing these insurance contracts, probably attorneys, and they should have made that clear if they wanted the real property owner. Now, there's an argument that a developer, if he was developing commercial property, he'd have a commercial interest. But does the residential property owner have a commercial interest? I don't think so. Realize that this was a brush hog. They were brushing tag owlers and weeds from around a pond in this guy's backyard. It wouldn't be any different than if he hired somebody to mow his grass. This is a maintenance thing. This isn't a big improvement thing. This isn't a big contractual agreement to make big improvements in his backyard. This is just a maintenance thing. So he cut down the tag owler with a brush hog. So does that homeowner have a commercial interest? Does his property appreciate because of these? Probably not. So I think, Your Honor, that you should deny certiorari in this case, or better yet, I think you should affirm the Court of Appeals and find that Atlanta Casualty has a duty to defend and indemnify my client.
Thank you, Counsel. How much time? No time, I'm sorry. Pardon? There's no time left, I'm sorry. Okay, thank you. The case will be submitted.